Good evening, America. Once again, this is Fair Housing, It's the Law. I'm Michael Smith.
I'm MJ Borelli. We're with the Fair Housing Council of Central California, and we provide information, education, training, and enforcement relating to housing civil rights law pertinent to the Federal Fair Housing Act. And the Federal Fair Housing Act, which has been around since 1968, is about your rights as a home seeker or a tenant in real estate or rental transactions to not be denied housing because of your race, color, national origin, religion, gender, disability, or the fact that you have young kids in your household.
Oh, okay. Sounds good. So,
I think what we want to talk about today is something that has not necessarily been considered a federal area of fair housing, but recently has kind of moved into the fair housing scene by virtue of a very recent memorandum that was issued by the United States Department of Housing and Urban Development, or HUD. HUD has regulatory authority over the Fair Housing Act and a lot of other housing laws. And this is based on kind of this nationwide trend that involves discrimination against people as home seekers, renters, because of their source of income. Now, source of income is not a protected area under federal law, and we're going to talk about what source of income means, but it is a protected area under California law, where there are prohibitions that have been in place since 1988 in California against landlords who discriminate against home seekers or tenants because of their source of income. And this can include a person who has a Section 8 housing choice voucher. What we have is a trend, and this is happening all over the United States, but it's really, really become pronounced right after the pandemic and the lockdown and the moratorium on everything from evictions to, paying your rent in California. So since about 2021, there have been a rash of landlords and property companies that refuse to take a person's Section 8 voucher. Well, this prompted the state legislature in California to pass laws, some of which went into effect in 2020 and have become a little even stricter the beginning of this year, 2024. And that is, it's against the law in California for a landlord to refuse to take a person's housing choice voucher, their Section 8 voucher. Now, interestingly, during the pandemic, those people who had Section 8 vouchers, landlords could pretty much be assured that their rent was going to be paid by local housing authorities or whoever it was that was administering the Section 8 program in whatever county it might be in California. So landlords could be assured of having some income, wherein lots of people couldn't go to work or pay their rent in full or pay their rent at all for, a year and a half or more. There were all kinds of programs, as some of you know, that subsidized people or helped them or paid directly to the landlord rents that were overdue. I even talked to people, here it is, February of 2024, who still haven't paid their rent since the pandemic. So kind of some interesting things going on out there. And I would think if I have a Section 8 voucher, at least some of the rent's going to get paid, and oftentimes the portion of the holder of that voucher doesn't pay a whole lot of rent. Usually Usually, their payment is somewhere around a third of whatever their regular income is, and their incomes aren't necessarily high. So, since the beginning of this year, it's totally pronounced, totally law, that you have to consider a Section 8 housing choice voucher when you have a vacancy. Nevertheless, probably one of the bigger areas that we hear with people that call into our office at the Fair Housing Council of Central California, landlords who won't take their Section 8 voucher, or they have a Section 8 voucher and the landlord seems to come up with every excuse that they might not be qualified to rent their unit. Now, we, as a Fair Housing Council, we contract with the federal government to facilitate enforcement of the Federal Fair Housing Act. So our hands have been tied here for a number of years in terms of source of income violations in California. We really can't spend federal funds to investigate those kinds of claims, so we generally just refer complainants who have this kind of situation. We refer them directly to the state of California, to Department of Fair Employment and Housing, which has now become the Civil Rights Department for the state of California, and they are handling both housing and employment discrimination claims. But as of last week, we have received word from HUD and the National Fair Housing Alliance that indeed we can use these funds to investigate these claims of housing discrimination that's based upon your source of income. Now, what a source of income means, that all sounds like, government jargon, but source of income is whatever kind of income you have coming in. It could be an employment insurance, it could be a part-time job, it could be SSI or Social Security Disability or Social Security or TANF, otherwise known as welfare payments. Anything that is your source of income, and the landlord doesn't want to rent to you because of where your income comes from, and housing choice voucher is considered part of your income because that's at least worth a month's rent or more. So that's what source of income is. I have dealt with landlords in the past in source of income violations that also were about the kind of work you do, where the landlord didn't want to rent to you because even though you may have made legitimate income, they didn't like where it was you were working. I had a lady complainant once that had a job as an exotic dancer in a nightclub, and she worked about 4 nights a week, and she made really, really good income, probably $2,000 a night. And the landlord didn't want to rent to her because of what her job was. So that would have been a violation of source of income too. Very famous case in California involved a man who in a Bay Area county had, now this would have been in the early 2000s, this man had a pretty prestigious profession, job. He worked in finance, and he had to quit working because he came down with full-blown AIDS and was unable to work. So his income changed, and he became a recipient of Social Security Disability. And living in the Bay Area, where rents have always been, pretty high, he was finding difficulty finding an affordable place to live, and he didn't have a Section 8 housing choice voucher. But he did have a relative who was paying his rent. And so he went to apply for a place to live, And when they saw his income, oh, you don't have enough money to live here, you don't have enough money to pay the rent, he said, well, my mother is paying my rent, and she will provide an affidavit and proof of her intention to continue paying my rent. And they denied him. And this became a case that was began with Department of Fair Employment and Housing, and I believe the fine for those that management company in the apartment complex where this disabled man, because he was considered disabled, they were fined something like $1 million plus attorney fees and court costs. So this is real serious, whether it's a state or federal violation. These kinds of end results can happen in terms of, compensatory damages and punitive damages to a landlord that refuses to uphold the law.
So is that like saying someone's that type of situation? Is that common? Just say someone goes and apply, and is it useful other than with like disability check or Social Security if you say, well, this is how much I make, but I got this person that's gonna
right.
pay
That's
for me.
That's a source of income.
That's a source.
Your mother over there that's going to pay your, $2,600 a month rent. Certainly that's a source of income. And a landlord has to rent to you. I think one of our last broadcasts we talked about. We didn't talk about source of income, but we did talk. Well, we talked a little bit about source of income.
We was talking about how to maintain your apartment.
Exactly. So sometimes we were talking about deposits also that landlords might charge, and individual policies like you have to make 4 times the rent in order to live here. And once again, if you're receiving or if you have possession of a Section 8 housing choice voucher, whatever your portion of the rent is, it could be, $70 a month, $200 a month, whatever it is, that's the base point that the landlord has to calculate in terms of 4 times the rent. Obviously, you wouldn't have a Section 8 housing choice voucher if the rent's $4,000 and you're making, $16,000 a month or whatever it is. So one of the things that this HUD memo that came down on the 12th, last Monday of February, was that federal funds from agencies like the Fair Housing Council could be used to discover whether or not, indeed, and to substantiate a claim that, this landlord doesn't want to rent to me because I have a Section 8 voucher. Now, we have various and sundry investigative tools, including simulating transactions, which is one of the primary methods of investigation, kind of like a secret shopper type situation, but a little more controlled and regimented. We can now use those tools, but one of the things that we've discovered with Section 8 folks is if we look at all the complaints that we receive, a vast percentage of those claims, interestingly, the folks are generally people of color or some other protected class, could even be disabled folks. But I've noticed going through some of the complaints that we have logged in that the majority of the folks that call us to complain about a landlord that doesn't take a Section 8 voucher tend to be African American or Latino people. So folks of color, well, that puts them in a protected class under the Fair Housing Act. So sometimes we might be looking at those complaints in a number of ways, that this is maybe a race complaint, or race discrimination complaint, as well as a source of income complaint. And I think it's one of the things that's paramount for us is there's really two kinds of cases that we can make, either for injunctive relief in the federal court system or administrative lawsuits through HUD or Department of Justice. And that is one type of complaint. We have direct evidence that we can substantiate. It either could be statements from landlords or property managers, or we're surveying other applicants or tenants, and it seems as though they were treated differently or given different terms, rules, and conditions whenever they tried to lease a property, and they tended to be folks of color. So now you have a race complaint. So those direct evidence complaints based on the statement, or perhaps surveying other tenants or applicants insofar as how they were treated in terms of trying to get a place to live. Or we have another kind of complaint that's called a disparate impact complaint, and that stems from a policy, for example, from an apartment complex or a property group or a landlord, that has the effect of discriminating against folks because of race, color, national origin, etc. So this is how we are now treating these source of income complaints. This is a kind of a serious issue in California, and I really, once again, I don't get it, because one of the assurances you have as a landlord, if you are contracting with a housing authorities and a person that has a Section 8 voucher, you're going to be guaranteed the largest portion of the rent. And even as rents go up, you're going to be guaranteed the largest portion of the rent. Not only that, most of these housing authorities are paying these rents well in advance. Now, certainly, the person that has the voucher is required to pay the rent on time, just like anybody else, regardless of their income. But even if they were late on a portion, or even if they missed a portion, you are still guaranteed a substantial part of the rent. And we get callers every day at the Fair Housing Council from folks that are having real difficulties in paying their rent on time anyway. So, this seems to be kind of pervasive as well in this new era post-pandemic, where a lot of these problems probably stem from, because certainly we weren't seeing the rejection of Section 8 applicants to the degree that we do today post-pandemic. So if you're a landlord and you happen to be tuning in, or you're a property manager, you need to really, 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 really pay very special attention to what we're talking about here. It's illegal to refuse to rent to somebody because of their source of income, which would include having a Section 8 voucher. And I don't care how tony your apartment complex is, it's against the law, and you're probably going to get sued, which is not a pleasant situation. Now, if you're a victim of this kind of behavior from landlords, you need to contact us at the Fair Housing Council of Central California. You can reach us by telephone at area code 559-244-2950. If you're out of the area, out of the San Joaquin Valley, that is area code 888-498-FAIR, F-A-I-R. And you'll get through to us. We're going to take your complaint, and we're going to investigate it.
Thank you, MJ. Once again, I'm Michael Smith. And remember, Fair housing is the law. Don't get caught. It's not worth it. So do your best to do the right thing.
And it's expensive. Do the right thing.
Do the right thing.
Thank you.